Just reconnect with Benedict Phiri, legal analyst. Mr. Phiri, thank you so much for making the time to speak to us. I hope you were listening into that conversation with the spokesperson of the Jacob Gedleyihlekisa Zuma Foundation, saying justice for the elite. What are your thoughts about what Mr. Manyi had to say?
I think it's really an unfortunate and reckless statement to say it's justice for the elite. I mean, this matter was ventilated in court and the arguments were there. I think Mr. Zuma's arguments, particularly on the urgency, were not as persuasive as the president's arguments and didn't track the law, even the question of jurisdiction. I think the president's advocate set out a long list of authorities that have been clear for decades to illustrate that a private prosecution can be interdicted by a civil court and it's not a matter for the criminal court. And you heard Justice Sutherland talking through that authority as well as what he called constitutional error authority to the same point and effect. So I think it's really very much not fair and quite gratuitous, that statement, given how Justice Sutherland set out the basis for the decision of the full bench. And I think even the question of the harm, it was clear that Mr. Zuma had misconstrued what the harm is here. The harm was really the fact that there would be a curtailment of constitutional rights on the basis of a potentially unlawful process. And I think that is harm that has to be interdicted. So I think the decision was right, and I think the statements are quite gratuitous and unfair based on the rationale of the judges that we've just heard now.
Just how Judge Sutherland unpacked the process of a nolle prosequi, how it's a reserve for the state and how it moves to the private side. Was that good enough to just take us into how the bench processed this application?
Yeah, I think it was important for him to articulate what the parameters of this judgment were, and essentially they related to urgency and whether the rights, the requirements for an interdict were met. He did highlight the questions that would be in front of, the Part B court, to say there's a number of questions which are new, even in law, relating to the issuing of a nolle prosequi certificate that court would have to traverse. And I think I like the fact that he has indicated the areas which would become up for contention. And he actually said if the president was successful on even one of those areas, then it would be a ground for the setting aside of that nolle prosequi and that summons. And on that basis, the interdict could then be granted.
So just a quick one to let you go. This Part B that we keep talking about, how is that going to unfold?
So, Judge Sutherland gave directions to the parties to attend a case management meeting with him so that, they could actually set out how that Part B is going to be heard and when it is going to be heard. I think it's quite clear that it should be expedited. And I think, the fact that Judge Sutherland, as the Deputy Judge President, will be handling that himself shows the seniority and the seriousness that the court takes that particular application. So once I think the parties have sat with Judge Sutherland, there will be an indication of when the matter has been set down for further argument.
Thank you so much again for making the time to speak to us this morning.